I have called him few days back. He was searching for his friend. Thereafter today also called him, but it will serve his purpose because his MA was dismissed for default for enhancement. 2 lakhs only granted to him. That is.
So this case, how much you want to pay?
But whatever the lordship could say.
Thursday. No, but Mr. Counsel,
Ali, question
question is it is dismissed for default.
It is dismissed for default 30 days.
Which was dismissed for default?
Miscellaneous appeal for enhancement.
Appeal is dismissed for default.
Yes, enhancement on the claimant was dismissed for default.
On the ground?
Non-appeal.
He has not appeared.
For default.
So there is.
Did not remove the.
Is there any restoration application filed?
It is a restoration. I mentioned that restoration. The 30 days delay, it will be restored. If your lordship is not willing to consider it.
No, because the delay has to be controlled, the main appeal has to be restored, then again the main appeal.
Then your lordship side.
Yes.
It can come tomorrow if your lordship so please. File a.
Give it tomorrow.
Okay.
Tomorrow.
With the lordship's permission, may I mention a second appeal, madam? The issue with respect to the execution is listed on the 18th of this month, madam.
Execution case filed.
Execution before the trial court, madam. I'm facing an eviction in the execution. Bailiff has to be appointed to this matter.
You are the.
I am the original defendant in the.
You are the tenant.
Yes, madam.
So what is both the findings are against you?
One finding is against me. This completed.
What is the finding against you?
There is a disputed question of the title with respect to the landlord, madam. Both do not have a title over the property. I am in possession of the property.
You are claiming title.
I am not claiming title. That it should not be
Dispute of title between whom?
between the landlord and the tenant.
You are the tenant.
I am the tenant. The landlord also does not have the title.
It's not necessary. What is the question in the eviction should that only the title holder should be the landlord?
Whereas even my grounds can hear me on merits.
Yes.
Deeply.
It is defect free.
It is defective.
If defect free under order 41 or 12. Under order 41 to 11. Give a slip.
My lord, may I be permitted? The second appeal, my lord, second appeal 144 of 2020, and the original plaintiff, we have filed a suit for specific performance of agreement for sale. Both the trial court as well as the first appellate court has given a finding that time was the essence of the contract, and
You did not perform your part.
no, the defendant, who was the owner of the property, had to get some permission which was not taken. And since within that time frame the permission was not taken, so specific performance of agreement, suit for specific performance of agreement was not taken. Now the original defendant, that is the landowner, is trying to create third party rights by selling the suit property.
Yes.
One second appeal, my 2018. Just want to try to dispose of myself. 2018. Second appeal.
Who are you?
I am the appellate man.
They are trying to dispossess you.
My.
So
I am my.
what was the suit for?
Who for title right title man.
Execution case filed.
No, execution case is not.
Then how can they throw you?
Without any order, without any competent court order matter, state government of Jharkhand is party, no private party, district administration trying to dispose of you without any order matter.
Once they disposes you, if they
I already filed IML in this
if
case.
they disposes you, then you come. There is no execution case. It's a second appeal. Without execution, how can you? Who is the plaintiff?
Well,
Who was the plaintiff?
client is a private party.
You are the plaintiff.
I am the plaintiff.
What was your prayer for?
My right title of interest honor.
What is the finding on possession by both the courts below?
Adverse position, my lord.
What was the finding of both the courts below in respect of possession?
Well, I am position 17 years old, my lord.
That is your submission. What is the finding of the court in respect of possession?
Sir, no, my lord, that is finding no order for disposes me, my lord.
Mr. Counsel, tell me, is there any finding that you are in possession or you are not in possession?
I am in position.
There is a finding that you are in
I am
possession.
in position.
So, if you are in possession, no one can
My
dispose you without a
I got that that purpose, my lord. Without any automatic competent court, my lord, he tried to dispose his goods. I for the photographs of the respondent authority, my lord. I file IA, my lord.
You have filed.
I filed.
File then mention after filing.
My filing already I filed IA, my lord.
I for
Stay of the proceeding, my lord.
stay of what proceeding?
Proceeding, my lord.
What proceeding?
Well, not back in.
Stay of what proceeding? What is the proceeding?
Not disposes the matter without any.
What is the Mr. Counsel, you have filed this IA under which section? Which provision of law? First let me understand.
Well, for that.
Under which provision of law you have filed this IA?
Well, in second appeal, matter.
Under what provision of law I am asking you?
Well, without.
Under what provision of law? I am not asking the reason for filing IA. Tell me under what provision of law you have filed IA. There is a provision of law. Under what provision of law?
Without here, I already filed.
That is the ground. You tell me what is the provision of law you have filed the IA. Under what provision? I am asking a very, very simple question. Under what provision of law you have filed the IA? Tell me, under what provision of law?
Well, maybe
Under how many provision of law you can file the IA in these type of cases? You tell me. How many provisions are there? What are the provisions available to you? Tell me.
Order 41
Rule?
or Order 41 16 Order 41
Rule 5? What is Order 41 Rule 5? Stay of operation of? So why should it be stayed?
Without any competent court order,
Why should we stay? There is another provision, Order 39 Rule 1 and 2.
Matter 39 1.
So?
Well, maybe
You say that there is no execution case.
without any order of competent court matter.
Yes.
I tried to disclose this.
What have they done? What have they done?
I have no option.
What have they done to dispossess you? What have they done to dispossess you? Tell me. What is the cause of action?
My structure is demolished.
Your structure has been demolished.
My boundary wall, that thing is erected. My boundary wall.
So what is the petition? You file order 39.
I
Why? I don't know what you will file. Whether you will succeed or not.
I
You have prima facie cases against you. You have lost in both the case courts.
but my appeal is pending. If the order 41 rule 11 may be heard, I will this appeal.
No, order 41 rule 11. You defect free under order 41 rule 11 on Thursday.
Apply.
No, 1 minute. 1 minute. You already mentioned. Yes, Mr. Lord.
From Delhi Government, serial number 50 under the heading final hearing, 1st April 87 of 20, Mr. Manoj Kumar for appellant, Mr. Bindu Kumar for respondent.
Yes.
Lordship,
Yes. LCR.
first appeal against the award and final judgment of the criminal under the Land Acquisition Act.
Yes.
So first of all, your Lordship, the Land Acquisition Act number 26 of 2017 Act is stated, Lordship.
Use the microphone, Mr. Counsel. You use the microphone.
So
Read the award.
the awarded two awards, Lordship, award number 9 and award number 16. That award number 9, Lordship, for the compensation of the land, about 9,000 something, Lordship.
So this is a challenge to award number 9.
Then Lordship, the criminal order. Criminal order. And it's the
Page 31.
and it's the page 31. Page 31.
51 years.
The case is
Yeah, award page 9 of 9.
The case is numbered as land acquisition case number 9 of
9.
How many cases were there?
One.
Only land acquisition case, only one.
Yes.
Okay, read the.
Yes, Lordship, this is the award Lordship.
Yes.
Read this award Lordship. from the paragraph 4.
Start from paragraph 1.
Start. The present case arises out on the basis of the case made by the prosecuting officer by order dated 26/2019 in connection with application number 36/2017, whereby the prosecuting officer acquired land in part of 6-story building and showroom situated at Jack PS number 256 National Area 30.084 Ismi, submitted therefore on by Srinati Aside Hub, while from the Indian Hub for construction of overbridge in between the city and the Karnataka railway station near river crossing 4E, Saptani, Nagar Devra. The award number 9 was prepared for rupees 96,335 for acquisition of land near measuring 3.650 Ismi. And award number 16 was prepared for acquisition of the 5,400 square feet in super build-up area by the main road side and 525 square feet area of single store showroom at rupees 92,53,720.
Just a minute, let me be clear. You see, it has been written that showroom situated at Madarichak measuring 30.084 decibel.
Yes, the land.
The land.
Land.
So the land is acquired is 30.084 decibel.
650.
No. What is the land acquired? What is the area of the land so acquired?
Lordship, as per the notification lot in year 2017, 1,590 square feet area acquired.
You come to the award.
Yes.
Land again.
Yes.
Read this first paragraph again.
And yes, the award number 9.
Acquired a land and part of 6-story building and showroom situated at area. So 30 decibel was not acquired. 30 decibel was not acquired.
There are 3 parts which are required, which is in the subsequent part of the order. The first.
So the land is 3.650 decimal, which was acquired. Okay.
As per this
Award 16 was prepared for 5,400 square feet in super building.
Yes, 529 and single story showroom at rupees 92,50,720. Feeling is satisfied with the same, the objector additional file objection before the LO ever and pursuant to that this reference has been made to this authority under the provision of section 76, right to fair commercial, transparency and recognition rehabilitation and settlement act 30. After receiving the letter of reference from the office, a district land acquisition officer Deoghar by letter number 77 dated 26/2019, notice were ordered to be issued to the parties on 28/6/2019. The petitioner objected and opposite party. The state of Jharkhand appeared before this authority and filed their objection and relied respectively. The case of the petitioner objector is that the objector is owner of the land appertaining survey plot number 25B, 255B, being part of Masori Jamabandi number 22885 in Deoghar Town Police Station, Sub-Division and District Deoghar. The state land belongs
Just a minute. So paragraph 3, there is no dispute?
No.
There is no dispute.
So let's consider the paragraph 4. That is the submission of the respondents of objector laws. It is further been aware that the petitioner has been concerned and acquired 12,392 square feet of land by virtue of registered static number section set, registered static number section set, registered static number section set, and there is no ambiguity on the point of ownership of land in question. There is no dispute.
No dispute.
The land in question is the solid transferable land and it is situated in commercial area. And this fact also finds support from the report of Kamungo dated 15/5/2019 submitted to the district land acquisition officer in LA case number section says that Kamungo has also reported that the land in question belongs to the objector petitioner and her family, which is transferable land and the fixed market value of this land is rupees 28,75,862 per decimal. He has also recommended for rectification in compensation as per market value rate fixed by the collector. The report of Kamungo also stated that the collector, without following the procedure of section 26 of the Act, and without taking into consideration the rate already fixed by the collector, and as per the chart of registry office, the rate has been arbitrarily fixed at rupees 8,32,955 per decimal. This is not acceptable to the objector, petitioner, and her family. The area where the land in question is situated in commercial area, for which Deoghar Municipal Corporation is also realizing tax at commercial rate from the objector, petitioner, and family. The objector and family acquire the said land to commence their business for their livelihood, and with that intention, leaving the western part of the land over which the residential house is existing in this site just parallel with eastern deed 70 feet wide road. This objector had constructed their substantial and loose construction into separate blocks, leaving only 11 feet wide space in between the two blocks for the ingress and outgress of their residential house. For coming to the main eastern 70 feet wide PWD road out of the said blocks towards the east south corner, the objector and her family have constructed a multi-story building, including basement towards the roadside, covering to 2,400 square feet. The front portion of the which is 60 feet long along with PWD road and 45 feet wide to the back portion. In the ground floor of the above building, 2 big rooms are constructed, and one of such room is being occupied by her son Praveen Sandhi and doing personal business in the name and style of Praveen DP World. While another room in possession of a tenant, all four first 2 floors of the said building are in possession of different tenants and getting monthly rent amount of rupees 80,000, including the rent of basement. The objector has also constructed another building which is a single story, 20 feet high building situated by the side of the site with a road and showroom of MRF tile is existing, covering a total area 1,382 square feet, and the business is being run by her son, Praveen Sandhi. The municipal corporation is levying tax at the rate of rupees 85,500 per year for the multi-story building and rupees 382 per year for the single story building, a commercial rate. The collector states has fixed the rate of 5,302 per square feet for roadside super built-up area, and as per calculation of rupees 5,400 square feet in super built-up area by this roadside. This is multi-story 6-floor building and rupees 525 per square feet front portion of the single story building has also been acquired. It has this rupees square feet. Yes, this is. It has also been stated objector as family are entitled to get compensation of rupees 2,86,380 for multi-story portion and 27,83,550 for the built-up area acquired in the said single story building. It is further the case of the objector that the entire acquisition proceeding has been proceeded in the name of the objector, petitioner namely Asajha and her family, and award number 9 and 16 have been separately prepared for the acquired land and part of 6-story Pakka building, to which the written complaint by the objector petitioner was placed before the authority concerned, but the award in question has been prepared in the sole name of the objector, petitioner Asajha. However, the husband and son of the objector Asajha have no objection in this regard. It has further been awarded that the necessity to file the objection by the objector petitioner, the authority for sale and on behalf of family had arisen as to the authority without complying with provision of the Act 2013 had fixed and assessed the amount of compensation for the acquired land and building. While determining the assessing the amount of the compensation for the acquired land and building, the authorities concerned committed irregularities. It has further been awarded that the acquired land and 6-story Pakka building in question is situated in the commercial area, existing just contiguous place of 70 feet wide PWD road, which is all around commonly known as a circular road, and total area of 1,590 square feet of land with multi-story commercial Pakka building just of PWD road has been acquired under this scheme. As per the provision of Section 26 of the Act, the procedure has been laid down for the determination of the market value of the land acquired by the collector, under which the collector shall adopt the criteria in assessing and determining the market value of the acquired land, which has already been fixed by the collector, and for registration of such land of sale deed, a stamp duty shall be payable under the Indian Stamp Act shall be the market value of the acquired land. An amount of compensation shall be fixed on the basis of said market value already fixed by the collector, against which the stamp duty is payable on the basis of the said fixed market value. The collector has already fixed rate of market value of the land and the building of the area where the land and the building under request is situated. As per the market value fixed by the collector, the market value of the land in commercial or by site of road is rupees 28,74,862 per decimal, and on the basis of said value, the stamp is required to pay in case of the transfer of said land by sale. In the present case, the rate of the sale of 50,190 square feet of land would be rupees 1,04,93,240, but the concerned authority had calculated the amount of compensation for the required land only 60.58 paisa per square feet. The amount of compensation at rupees 96,335 and which is arbitrary, and again the criteria assessed and determined the market value as contained in Section 26A of the Act. It is further stated that since the above said land and building made thereon has been acquired and systems shall be demolished, due to which the business of sector and her family shall be ruined, and remaining part of the house shall be reconstructed, and therefore suffer a loss of rupees 5 crore. Thus, it has been paid the prepare an award for the amount of which the objector and her family are legally entitled, and to further direct the collector to assess the amount of compensation provided under Section 29 of the Act. The opposite party also filed its rejoinder commitment statement stating that the LA case number section had been registered in this court on the basis of reference made by District Land Acquisition Officer Deoghar of later number section for determination amount of compensation in favor of the petitioner objector Asaka for self and on behalf of her husband and son for acquisition of 3.650 of the land along with the portion of the commercial building standing on the portion of the acquired land bearing Deoghar Township number sections operating the Kamalmandi number Netna within Deoghar station subdivision and district Deoghar. The above portion of the land and part of the building in question has been acquired in LA case number 56/2020 and the scheme for construction of ROB at a certain Nagar Deoghar. It is further added that for calculation of the said land and the building in question, award number 9 institution had been separately prepared for the acquired land and part of the building, but the petitioner objector Asaka had raised objection on the point of an amount of compensation and the basis on which the rate and value of the land in the acquired portion of the building has been assessed, and on that basis has claimed to enhance the amount of compensation on the basis of valuation of the land and house already fixed by the collector of the in the prescribed manner, and on the such objection raised by the petitioner, this matter has been referred to this authority. It has further been averred that the statement made in paragraph 1 and 2 of the objection filed on behalf of the petitioner objection for self on behalf of the husband and son regarding acquisition of land and petition of award, and objection raised by the petitioner for self on and on behalf of husband and sons are partly correct, except under assertion that the acquired land and building had not taken into consideration about the provisions of the Act of 2013. In this regard, this fact is not correct. It has further been averred that regarding the assertion made in paragraph 13 of the objection petition of the petitioner objector at the land and part of the Pakha building in question are situated within the depth of 70 feet wide PWD road all along and commonly known as circular road, and the total area of 1,590 square feet of land. The front portion was side Pakha building has been acquired under the scheme are correct and as such permitted It has also been asserted that at the time of termination of valuation of acquired land and pending the petition of the after notice under section 20 of the Act, the authority had valued the assessed area of the acquired land and building on the basis of the cost then available with the authority, and under such circumstances the land was assessed as the non-transferable land. And the value of the acquired land, the building of the objector petitioner was also assessed for non-transferable land, but later on the petitioner objector assigned a sale on behalf of her parents and self-produced on behalf of produced the original document and filed objection challenging the amount of compensation against assessed to the land and building, then only in conspect that actually in the record of right the acquired plot of number 255 is recorded as the custody land from the documents and from the land receipt issued by the Jharkhand municipality and circle officer. It was established that actually the acquired land is transferable land and the land in question acquired belongs to petitioner and her family member by virtue of registered serial number such and such, registered serial such and such, registered deed such and such, in the office from the user of the document. It is also admitted position now that the acquired land and the building exclusively belongs to the petitioner objector, to the petitioner objector aside and a family member, and the transferable land. It has also been asserted that the rate of acquired land in question has already been fixed by the collectors before on the day of notification for application as per the chart available in the Jharkhand Registry Office. The value of transferable land in commercial area has been fixed at rupees 28,74,862 per decimal, and as per the chart available at the Jharkhand Registry Office, the rate of land existing in the commercial area is fixed at rupees 6,600 per square feet, and this fact is supported in the report dated 15th May 2019 submitted by Carnival in customer satisfaction. Apart from this, the market value of the roadside built-up area is fixed by the collectorate at the rate of rupees 5,302 per square feet in accordance with the chart available in the Registry Office, and it admitted that the front portion of the built-up area situated by the side of road and 525 square feet of front portion of single-story building has also been acquired, and it is made of total area received 1,590 square feet or 3.65 decimal has been acquired. It has further been awarded that the authority, while assessing the market value of acquired land, ability could not assess the actual value due to non-protection of the original document by the petitioner before the authority was. On the basis of reading of the parties following issue here framed by the learned BDJ, has logic whether a total area of 1,590 square feet land with part of multi-story pakka building acquired in the case is situated in commercial area of Jharkhand. Second is lawsuit whether the award number 9 and 16 against compensation of acquired land and part of multi-story pakka building have been prepared without considering market value of the acquired property as per the provision of section 26 of the Act. Whether the objector petitioner is entitled to enhancement of the amount of compensation. In support of this case, three witnesses were examined on behalf of the objector petitioner, the Asad Jha, Niranjan Jha, and Prashant Sandhi, all the family members. PW1 Asad Jha is the objector petitioner here. This is very important, the position of it, because that the preceding case has been referred by the district land acquisition officer on her objection raised regarding the amount of compensation and acquisition of land pertaining to survey plot number 155B, Basodi Jamabandi number Rossi 155B Rossi is plot number 255B. So there 155B under the investigation by the CDI. So I am not placed, but this is not on the record, but
Mr. Counsel, let me be very clear. You should be also clear on this matter. You argue on what is on record. Don't go off the record.
No, this is the there are our mistake of the time. This is a
No. If there is an error on the record, you say this is an error. Don't argue anything which is not there in the evidence, which is not on record.
right.
Yes.
Plot number 1 IP Jamali Satan, Southern America, PS Satan, 3.65 decimal has 6 story and 1 story. Building which was acquired by the government and compensation was fixed, which was not as per the market value. C has further deposed that she herself has gained and her son purchased the land in question. What said in number certain set, said in number certain set, which number certain set, the name of her estate, her son, as well as her salary have been noted in revenue record and paid in rate separately. She further deposed that the name of the land of 1 district is equal to 435.60 square feet in the acquired area, and this way land having area 3.6 district, which is situated in the acquired commercial area in Basori and sellable land and the same has been acquired. She has also filed receipt issued by the municipal area. Therefore, to prove that the land and building is situated in commercial area and they are also paying rent to the municipality, the opposite party have also admitted this fact in their written statement by saying that the said land and building is situated in commercial area in Jharkhand. The valuation of the acquired land has been fixed as 28,74,862 per decimal by the collector prior to notification to acquire this land. The authority have awarded amount of compensation of rupees 96,335 for acquired land of 1,519 square feet at the rupees of 6 per square feet. Further deposed that as per the government rate for super build-up area and commercial area, the value of the house is rupees 5,302 square feet. Her build-up area having 55,400 square feet and 525 square feet have acquired by the authority. She has further stated that the current portion of her 6-story building and single stories have been acquired and said she and her family is entitled for rupees 2,86,30,800 for 6-story house and rupees 27,83,550 for 1-story house. Our both houses are registered on the pillar would be damaged and the remaining part of the house would be built afresh. There are several tenants in her building and they are earning rupees 80,000 per month. Her son is also running in MRX at store having 1,302 square area, and due to demolish his business would be closed and all the tenants would get property due to this reason. Also, they will suffer a monetary loss. Our family is paying tax against the income which they receive from the building under reference. The opposite party had initiated the acquisition proceeding against her. Only altogether her husband and her son are also shared in the sale. Her son and her husband have no objection if the whole amount is paid in her name only. In the cross-examination by the opposite party, she has stated that in this case she has filed 3 sale which are in the name of her husband, son and herself. PW2 Viranjan Jha, the state of the is a state of Pillar State Act. His wife is the petitioner of the trade. His case is instituted against his wife for today the land acquired. In this case is in his name and the name of his son, but his wife has filed her person in written or in this case which she also admits. In his cross-examination, he has stated that the land which they have obtained through 3 sale deeds have been acquired. They further deposit that it does not know the rate of commercial tax and residential tax of their municipality, but rupees 85,000 towards commercial tax and 1,000 house tax is being paid. He has not filed report regarding assessment of land after demolition of house. PW3 Prashant Sandele, the son of PW1 and PW2, he stated in his examination chief that his mother is objected in this case. Initially, this case was constituted against his mother only. He and his parents are also the owner of the land. His mother has filed a written statement in this case, and he also admit this said written statement further deposit that if the compensation amount is given to his mother, an award is being prepared in her name, then he would have no objection, not raise this same in future. In his first examination, he stated that he has obtained this land by way of gift. He also got mutate his name in the receipts. Apart from the oral evidence, certain documents have also been exhibited marked on behalf of sector because these are called this paragraph is very important, Rossi, because entire document has been filed photocopy, not a certified copy, not a original copy. This is the entire document, Rossi. These are photocopy. So Section 65 of the business code is not admissible, Rossi. I place this constitutional property in this clause. Next paragraph, the paragraph 11, Rossi. The opposite party did not examine any witness. Accordingly, its evidence was closed. While ordered it is not now, I got some document verified by the counsel opposite party, which have been marked with there as pending. Copy of letter number section of forwarding letter number section. The government counsel for both parties advanced their argument again and also filed the respective written notes of document. I have considered the oral as well as written notes of the document of both party, and the evidence on record might be so wise finding is as pending. Issue number 1, whether the total area of 1590 square meter land in part of the multi-story property acquired in this case is situated in commercial area of the land. The case of the petition is that she, along with the husband, PW1, 2, 3, is owner of land front of the commercial 6-story building pertaining to survey plot number 255B, being part of Saudi Jharkhand case number section set within the town police station of subdivision and district Deoghar. She has also placed for the court a SAD number section set which show that she and her son are the owner of the property in question. The petitioner has also filed a certified copy of mutation order Exhibit 10 and Exhibit 10-1 passed by the circle officer with the support of Lordship and only mention regarding the exhibit document Lordship. There is no witness of the objector Lordship exhibit any document Lordship. So this is the past is circle officer in support of her case. She has also filed a certified copy of mutation order Exhibit 10/2 passed by the circle officer in favor of the spent of petitioner. We saw that the CAD number 19 suggested respect of part of the property in question. The petitioner along with her state and son appeared in the witness box PW1 to PW3 and also filed their respective evidence by way of affidavit, but no question was raised with regard to their ownership for the land and building in question. Moreover, the chairman of the party admitted in his written statement that the government has acquired 3.65 decimal of land building belongs to the petitioner and her husband and son under the scheme for construction of ROD at Sattannagar Deoghar. Therefore, it established that the acquired land and building in question acquired for ROD belongs to the petitioner, husband and son. Now the question is whether the acquired land and building situated in commercial area or not. It has come in the evidence of petitioner PW1 that the property in question is a transport land and situated in commercial area of district Deoghar. In support of our case, the petitioner had relied upon the report of Kanunko, where it is stated that acquired land belonged to the petitioner and is used for commercial purpose. The petitioner has also relied upon the various agreements executed between the son of petitioner and tenants. This so that the 6-story building is laid out to different tenants who are running commercial activities from their respective person. The petitioner has also relied upon the report information received under the Right to Information Act, which suggests that acquired property belongs to the petitioner being used for commercial activities. A copy of Khatyam has also been placed on record. We suggest that the land under reference mentioned as a was solid right. It would not be out of place to mention here that the respondent of the party has not disputed in its written statement that the acquired land and building does not fall under the commercial area of district Jharkhand. Therefore, it stands true that the acquired land and building is situated in commercial area of Jharkhand. According to issue number 1 is added in favor of the petition. Issue number 2, the whether the award number 9 is issued against the compensation of acquired land and part of the multi-story building have been prepared without considering the market value of the acquired property as per the provision of section 26 of the Act. In order to prove the above issue, the petitioner stated in her evidence by way of affidavit that the acquired land and building exclusively belongs to herself, her husband and son, and same is also transferable land, and the rate of acquired land in question was already fixed by the collector much before the date of notification of acquisition and as per the chart available in the Jharkhand Registry Office. The value of transferable land in commercial area has been fixed at rupees 28,74,862 per decile. It was argued by the learned counsel of the petitioner that the land acquisition collector had fixed and assessed the amount of compensation for the acquirement and building without taking into consideration the provision of section 26 of the Act. To appreciate the contention of the learned counsel for petitioner, it would proper to reproduce the provision of section 26 of the Act as amended. Determination of market value of land by the collector. The collector shall adopt the following criteria in assessing and determining the market value of the land namely. The market value if mainly specified in the Indian Act for registration, sale for the registration of sale deed or agreement to sell the case may be in the area where the land is situated. The average sale price for similar type of land situated in the nearest village or nearest vicinity area. The estimated amount of compensation and argued upon under subsection 2 in case of acquisition of land for private companies of the land for public-private partnership project, whichever is higher, provided the date of determination of market value shall be the date on which the notification has been issued under section 11. The market value calculated as per the subsection 1 shall be multiplied by the factor to specify in the first schedule, where the market value under subsection 1 or subsection 2 cannot be determined for the reason that the land is situated in such area where the transaction is land are restricted by any other law or timing being enforced in that area, or the registered sale deed or agreement to sell mentioned in clause A of subsection 1 for single land are not available for the immediately proceeding 3 years. The market value has not been specified under Indian Act by the appropriate authority of the state government. Concerns specified in floor price or minimum price per unit area of the same land based on a price calculated in the manner specified in subsection 1 respect to single type land situated in immediate adjoining area. It is obligatory on the part of land acquisition collector to make an inquiry adopting different method measured under clause A to C of section 26(1) of the Act and to fix the market value at the rate whichever is found higher in the inquiry. If he could not determine rate of compensation in terms of subsection 1, the collector may resort to the provisions of subsection 3 of section 26, considering the above provision in mind. It is clear that the land acquisition officer did not follow the above provisions while fixing the amount of compensation in award number 9 and 16. Needless to mention here that the collector had passed award number 9 for land, award number 16 for part of 6-story building and single-story solo. It is clear from the record specifically in the written statement of this party that the land was assessed by the land acquisition officer as a non-transferable land, and the building of the petitioner was also assessed as a non-transferable. The opposite party was also admitted in the written statement that the acquired land is a bursary land and the land issued by the Deoghar municipality and the acquired land is a transferable land, and as per the chart available in the Forestry Office for the period of 1780, the valuation of transferable land in commercial area has been fixed at rupees 28,74,862 per decimal. But land acquisition officer Deoghar, while fixing the compensation of acquired land at measuring 3.65 decimal, neither considered the category of land nor applied market rate fixed by the government. I may say that it is a mandatory on the part of the land acquisition officer to check whether the land is transferable or not, whether the land is situated in residential or commercial area, etc., and apply the appropriate market rate of such type of land. It is not disputed that the acquired land is transferable land and situated on main roads, circular road, which is a commercial area, and as per the rate chart available in the Forestry Office for the year 2017-18, Exhibit A, the valuation of transferable land situated in commercial area has been fixed at rupees 28,74,862 per decimal. Regarding head to the above discussion, it is clear that the land acquisition officer Deoghar needs award did not consider the category and types of land and the prevalent market rate applicable to such land and fixed on rupees 8,32,955 per decimal, assuming the land to be non-transferable land. On the other hand, the valuation of one decimal land out of fixed rupees 28,74,862, and as the total amount of compensation of 3.65 decimal would come rupees 1,4,93,246 such and such lots. It would not be out of place to mention here that the story component is reported as the value of one decimal land to be fixed of rupees 28,74,862 in view of the above discussion. It is manifest as the Deoghar for the award number 9 without considering the prevalent market rate in terms of section 26 or section 1 of the Act, and as such the same is liable to be set aside. Therefore, award number 9 is set aside. The amount of compensation for 3.65 decimal land is fixed in terms of 1,4,93,246. So far as the valuation of part of 6-story building including basement and 1-story store is concerned, the case of the petitioner is that she also with her cement concern is the owner of the required 50,190 square feet land and 6-story building and single-story store by virtue of respective ready to Basori town the same 6-story building including the basement covering 2,400 square feet is constructed on commercial area leaving the western part of land over which the residential house is existing towards east of the said land, just parallel eastern PWD 70 feet by main road. The petitioner and family have made this construction in separate blocks. Leaving 11 feet wide space in between the state blocks, the son of the petitioner is also running the MRF tax showroom, covering total area 1,300 square feet and paying the tax to their municipality. The market rate of deluxe building apartments situated in commercial area for the period 1780 rupees per square feet. As per calculation of its upper built-up area by the main road side, which is a 6-story building and 525 square feet portion of single-story showroom has been acquired by government as part of the provision of section 26 to the 1 where says to actually get compensation of rupees 2 crore 86 lakh 38,800 for multi-story building and rupees 27 lakh 80,500 single story showroom, but opposite party has awarded the compensation amount of rupees 92 lakh 53,720. The opposite party also admitted in the written statement as per the written notes of the document that as per the rate of fixed market value of road side built-up area is a 5,300 square feet. It is further admitted that the front portion of super built-up area is situated by road side 525 square feet from portion of single-story building has been acquired, and in this way total area measuring 6.65 decimal has been acquired. From the principle of pleading of the parties and evidence brought on the court, it is clear that the opposite party has acquired 15,900 square feet of land, which is equivalent to 3.650 decimal, and this way part of this 6-story building along with the single-story showroom has been acquired, which is admitted fact that 5,400 square feet area from roadside 6-story building to acquire one floor of building is 64 into 5,900 square feet, and in this way total area of 6-story building 5,400 square feet. It is further and admitted fact that the area of acquired single-story showroom is 35 feet into 15 feet, 525 square feet, and this way the total acquired area comes to the 5,925 square feet. As per the rate chart, a sum of rupees 5,302 per square feet has been fixed for period of the night. This total area calculated with the opposite rate chart, then say it would come to the 3 crore 14 lakh 14,350. But the land acquisition asset valuation of the asset is 92 lakh 53,720. This clearly suggested that the land acquisition by determining the compensation amount will not fit the correct and proper perspective and fix the compensation amount at a very lower side. And as such, the sale is liable to be set aside and same already fixed enhanced at the rupees 3 crore 14 lakh 40,350. And accordingly, issue number 2 is decided in favor of petitioner. Issue number 3, whether the objector entitled to enhancement of the amount of compensation in view of the discussion made herein above, the petitioner entitled to receive enhancement compensation of rupees 1 crore 4 lakh 93,240 award number 9 and 3 crore 40 lakh 14,350 in award number 16. She will also be entitled to solidum at the rate of 100% on the enhancement amount of compensation. The learned from petitioner contained that the petitioner also entitled to separate compensation of rupees 5 crore in the term of rupees 29. We may say that the petitioner will not file in the list of detail that asset attached with the guideline and really not to matter filed before the guideline officer in regard as per property section 29(1), the collected determine the market value of building and other lower property of assets attached to the land or building which are to be acquired. Use the service of competent engineer or any other specialist in the relevant field. He may be considered necessary by him. As per the report, no application was filed before the land use officer. No value of thing attached to land building, nor the single letter by the collector for decision of this building. In the absence of any finding of the below report of the area, the contention of the petition cannot be accepted in the same written down. Order. Considering opposite facts and scenarios of the case, they are ordered to the petition entitled to receive compensation of rupees 1 crore 4 lakh 93,246 in the place of 96,355 in award number 9 and the 3 crore 14 lakh 14,350 in place of rupees 92 lakh, declared on 720 as the bid is also entitled to 100% on the investment amount of the system. The opposite party right to pay the opposite compensation amount within a period of 3 months to the business investment. So at this processing with the entitled compensation of the license. Lordship only arrested because all the admitted by the written statement.
Give me the dates. Lordship notice of acquisition.
Detailed dates, Lordship.
Dates. When did the acquisition proceedings start?
Lordship, the notification under section 11 Lordship published on the 6/11/2017.
Just a minute. This is under the new act? 13 Act?
No, yes, sir.
Section 11 notification is dated?
6/11/2017.
There should not be any dispute on these dates.
No, no dispute. This is the proposed area in the notification Lordship. 1519 start.
Just a minute. This is exhibit.
Exhibit Lordship. Exhibit all the document.
You have admitted all these documents. You have not objected. This section 11 notification is dated?
Yes, the exhibit 4.
Exhibit 4, come to it.
Exhibit 4 6/11/2017. Delivery notification Lordship. Thereafter Lordship.
Just a minute. This is exhibit 4. Read exhibit 4.
The fitness condition.
Just a minute. Exhibit 4. Page 30. Yes, read that.
अधिसूचना संख्या 812 dated
What are you reading? Exhibit 4 is something else. Notification of acquisition. Any case number?
6/11/2017.
No. What is this?
Also mention the date in the order sequence.
No, the exhibit 4 is not the notification.
And this is the
Section 11.
page
It's not
number.
it's not under section 11.
Plot times the page number 40 of the judgment.
No.
Photo copy of publication of preliminary notification for acquisition of land building under section 11 under the scheme dated 6/11/2017 is marked as exhibit 4.
No, this is the final.
Notification.
This is the final assessment. अंतिम प्रकलन की गणना तालिका.
That is the date of acquisition. That is the date of
This is
acquisition.
the date of acquisition. Where is the notice? First notice.
Notice is not executed. Lordship, my solution report was C. The entire report was not executed by the witnesses Lordship. It is self-executed by the court Lordship. And you see the statement deposition of the witness Lordship. There is no executed Lordship. This is is my humble submission. Second, you wrote the entire document with protocol.
No, just a minute.
Page number 40, can you see?
I want to see what was the area which was sought to be acquired. Show me that.
Lordship, at the only preliminary inquiry Lordship, under section 11 Lordship, the area so the proposed
Where is the
area,
section 11 notification?
there is no,
Where is it?
Where is the documents which we exhibited was the final notification of acquisition, Your Worship, that was exhibit 4.
As per Exhibit 4, what has been acquired? As per Exhibit 4, what has been acquired?
Now we will see a 10 page.
but this is not really recalled.
परियोजना का नाम जेसीडी बैद्यनाथ धाम स्टेशन के बीच केवल लेवल क्रॉसिंग 4E के स्थान पर ऊपरी पुल और रोड ओवरब्रिज. This is 36 of 1718. What is this land acquisition case?
Yes, sir.
Yes, sir.
The case was 36 numbered.
36. Total area 13.084 decimal hectares as per the records.
So total area is acquired is 30.084. Yes, madam.
The total area was 13,105 entire thing. And as far as
105.
of
What is it?
at last notice, page 2, internal page 2, last full ratwa, but fit में. At
where?
serial number 10 के नीचे.
Where are you going? This report. This is not.
What was acquired?
6/11/17 का जो exhibit 4 है.
Yes. Where is it?
प्रोसेस करना पड़ता है. टोटल
Show me what is exhibit 4, what you are referring to. Show me that document. No. Exhibit 4 is something else.
This
This is
document
exhibit 4.
exhibit more only. This is the different document. This is not exhibit. This land acquisition.
It is area case number 9. Yes, area case number 9.
There is no proper.
No, just a minute.
What is
It's a
exhibit?
photocopy. Yes, this is the same thing.
Some-
Same thing. Same thing.
But list, as per the order sheet logs, exhibit 4 is the notification logs. This is not a notification.
No, this, if you say that this has been acquired, the total acquired is 30.084.
other or personally involved in this matter, not only this person. So this area is so many persons.
No, total area is 30 decibels. Where is the notice issued to this person that what would be acquired?
There is no report.
Where is that?
Which is not exhibited.
What was acquired?
Your Worship, the judgment shows me whatever the
Well, your judgment is under challenge.
that they were never objected to this, but this plot and this area has been acquired.
Show me where is the notice.
Notice exhibit table.
Very good. Very good.
If your Worship permits me, I'll go to the local record master.
Yes, you go through the local records. You have not exhibited the notice itself.
No, we have not
One
exhibited.
thing about notice property, my learned sister finds a counter and there is the one document.
What is the question of counter in an appeal?
No,
What is the question of counter in an appeal?
no. But I only see that the 1180 square feet only acquired the land. I have the record.
No, that was your when we wanted that money, 3 crores and all. Your Worship wanted that money.
What is the record?
So, ultimately, we find other plots which we have.
What was acquired? I want to know what was sought to be acquired and what was acquired. Go through the entire records.
Yeah.
Come at 215. Come at 215. Go through the entire records. 215. इसके लिए होना चाहिए sorry yes
Under the heading buy and disposal, serial number 1, serial number 2, serial number 3 and serial number 4, MN number 622 of 50, MN number 399 of 50, MN number 400 of 50, MN number 34 of 50. Mr. DC Mishra for appealing in first case, Mr. Alok Lal for appealing in all the 3 cases.
why it was for final disposal for Lok Adalat?
No. He expired under full release of the awarded company.
No, but it is for final disposal. Let us hear this. What is this? What is the appeal?
But there are altogether 4 appeals. The first appeal is for by the claimants. The second is by the insurance company disowned their liability. And third is also for disowned liability for the government.
How many persons was involved?
There are altogether 2 in my appeal. And
In all the 4 cases, I am for the owner of the vehicle.
You are the owner.
Yes,
Arising out of the same award.
same.
How
Same
many
accident.
four appeals is this? Same accident.
Same
Not
accident.
from the same award. Which 2 cases arises from the same award?
Number 1 and 6.
1
1 and 4 is
1 and 4.
34. Give me 34.
And it's 622 of 2016.
622 of 2016 and 34 of 2016.
Yeah.
Yes, you are for the
That's I for the claim.
you are for the claimants in which case?
In first appeal.
622.
Yes.
Come this side. Your prayer is for enhancement.
Yes.
On what ground?
Because there are two persons, the father and son has died. Now, so far as the quantum of compensation is concerned,
No. This is for the father or the son.
but the claim petition was filed for father and son. My ground is that with respect of son, nothing has been paid. And with respect of father, also the future aspect, prospect and
So you filed only one application for claiming compensation for father and son both.
yes,
So far as father is, this is entirely for the father.
yes.
How are you saying this?
When it's we come to assessment of compensation, when it's para number 50, issue number 2, we will do it with the para 16 onwards.
Para 16.
Yes, quantum of compensation. It was the businessman arguing
Para 16, just a minute. Yes.
he was a businessman earning 9,000 per month, age is 30, the assessment was done, and thereafter the amount. But with respect of son,
Let's hear the.
Okay, this case perhaps the item number, second, notice could not be validated, sir.
We are hearing now case number 1 and 4.
1 and 4. So, Manoj, in this case, my request would be that this matter may come up after one of the matters which is pending before adoption with regard to the issue which is involving with regard to the Act liability policy.
no, as per me, there is no such question is involved. Reason is that if the question of act or the policy is there, can they read from the written statement it is there pleading? Then can they read from the
Yes.
evidence that it is
But
there written
my
statement?
submission would be let it come after summer vacation. Then I understand.
Let me understand first. Case number 1 and case number 4.
1 and 4, yes.
From
Yes, take
same
out.
number.
It is the same case and the claimant and the applicant.
What is your ground?
That is the only ground with regard to the Act liability policy.
This was an act liability policy.
Yes. Kindly come to paragraph 17 of my written statement. In the lower court record. Of course, there is automatically drafted, but the thing is that it will be used for commercial purposes.
Your case is it was used for commercial.
It was commercial purpose, but the thing is that the manner of occurrence we already will also see show that they boarded this vehicle as a member of the the Bharat party to catch the bus. Bus missed the station. Therefore, the driver, he was driving rationally.
He was the owner of the vehicle. Driver was the owner of the vehicle.
Driver was the owner
of the car.
It was a car, Maruti car. And they were traveling in this car as an occupant. Not even, let us assume that it was they were the occupant, not a commercially or the fare pay. But my submission would be that it was a policy having the act liability only purpose. So therefore, in this connection,
What is your plea in the written statement?
paragraph 17 make an please.
As paragraph 17 is that it is submitted that according to the terms and conditions of the policy and in view of the matter of violation of the same, the respondent is not at all liable to pay the amount of compensation or any portion thereof as wrongly and falsely paid by the applicant to the beneficiary. Submitted the accidental vehicle used as commercial vehicle, though registered as private vehicle, and no premium paid for carrying passenger to the insurance company and such, the respondent is not liable to pay.
Your case is that it is a commercial vehicle.
And there is no evidence.
Let us confine to the object of the statement. No premium was paid for the occupant or person traveling in the vehicle. Maybe it is a commercial vehicle, maybe they have said a commercial vehicle, but occupants were not covered. This is my contention. Who were the, except the owner, whoever was there, not covered.
So we to say that he is not a third party.
He is not the third.
Yes, there is that. May I refer one judgment of Honorable Supreme Court reported in 2001 SCC 195. And I will refer 5 paragraphs of that how the terms of contract with respect of insurance policy has been. But that's why that is 2003.
This is your only ground.
That is the only ground. That is the only ground.
But that cannot be a ground as well.
In that case, I would also rely upon the several judgments of the Supreme Court that Surendranath Lumba, that was the first issue.
But this is 2001 SCC page 195. My notes is technical to paragraph 4. That's 4 to 11 is that.
Paragraph
4.
Paragraph 4. Yes.
Now, according to clause E, section 2 of contract act, consideration is spoken of thus. The Supreme Court is considering what is consideration, agreement, contract, and how to motivate that. Paragraph 4, section 2D of contract, 2D, then the 2D definition is given. Similarly, clause E and F provide as under 2E. Every promise, every set of promises.
When was the case last heard?
Yes, it was
So as per my record, it was admitted on 16/1/19. 16/1/19 was the following a coordinate bench, and LCR was called for. And in terms of order dated 22nd of
3416 देखिएगा 3416 is the next case 395
399 and 400.
these are the
These
Arising
are
out of the separate, same accidents.
same accident, three accidents, but in these two cases, one or two notices were issued, but it is perhaps in the second case, the notice could not be served on the restaurants. One has left and two has died.
Just a minute, please.
Now it's paragraph 5.
Just a minute, just a minute. Just a minute. Go through the record of all the 4 cases. Go through the order sheet of all the 4 cases. Order sheet. Order sheet. This was the last कौन heading में था केस? At the last date?
Perhaps last it was for admission.
Last
Because
date कौन heading में था?
admission में थी, तो admit को आगे मेरे ख्याल से 16/1/19 has been admitted. Item number 34/16 was admitted for the
Which year में? 622. Last कब था इसको heading? 25/3/2021 कौन heading में था?
on item number 622
What is with the case?
was on 23rd of March 2021, and I-400 was on 6/1/2020, and 399 was on 20th of September 2019. On that day, notices were directed to be issued on the respondents and notices were filed, but report is that
Notices upon whom?
upon the respondents, but
Which respondent?
1 and 2, all the respondents.
Who are 1 and 2?
In 399, one is the claimant, 2 is the husband, 2 is the
Last.
claimant, 2 is also the claimant. But he is reported to have died.
और दीजिए.
399 claimant is
कब था? Last date? 25/3. Which case was listed? 620. 25/3. So it was listed with these 2 cases.
Yes.
Where is the LCR? All the 4 cases were listed. Oh, that was listed alone. So these 2 will be heard separately. LCR. LCR. You are referring to
Paragraph 7. Paragraph 17 of paragraph 17 of the release.
17.
Yes. It is submitted that
Just a minute. Of the insurance company.
yes. Insurance company of
Yes.
the-
Yes. It is submitted that.
It is submitted that according to the terms and conditions of policy and in view of the matter for violation of the same, this respondent is not at all liable to pay the alleged amount of compensation or any portion thereof as wrongly and falsely claimed by the applicants in the claim petition. It is submitted that the accidental vehicle used as commercial vehicle, though registered as private vehicle, and no premium paid for carrying passengers in the insurance policy, and as such, this respondent is not liable for
Insurance policy is exhibit.
Insurance policy is exhibit 2.
2.
Yes. As referred to the relevant is photocopy.
Exhibit Y. Insurance certificate is exhibit Y.
Exhibit
Y.
Y. Y or 5? No, 5 is the FIR.
As per my certificate copy,
If it is title claims over 20 or 70, this is the case.
No. This is 73. What is the case?
my case is
622 and 32.
What is the motor vehicle accident case number?
73 of 2009.
73 of 2009.
Sorry.
So where is 73? Where is the
The insurance policy is exhibit 2 by the claims.
Yes, it is 2. 73 is 2.
2?
In the other one it is Y.
This is the postmortem.
Postmortem is exhibit 1 by
This is also the postmortem. Exhibit 1.
1 by 1 and 1.
Exhibit 5 is the FIR or charge sheet.
Exhibit,
Charge sheet is
yes, charge sheet.
exhibit 5.
Exhibit
5 is charge sheet.
4 is the
Airship
Airship
certificate.
airship certificate.
3 is CC of judgment, probably some judgment was. And then
This is title claim suit number 19 of 7.
yes, and then 2 is photocopy.
Yes, to photocopy. What is this? What is this?
But it's from what we today insurance companies are doing. But
Private car policy and liability only.
Liability. This is my case.
But this means, if I may be permitted to place before example, from where they are interpreting it, that this is act on the policy, number 1. Number 2, where in their written statement they have said that it is act on the policy and the occupant is not covered. Rather, in the written statement they take some plea that since it is being used for commercial purpose, therefore passenger is not covered.
And no premium is paid.
Yes,
Let me
so,
go to another explain.
and then in the written statement there is no averment that it is an act on the policy and every occupant is not covered. Rather, they have cut down their defense and said that this is the policy for which premium is not paid for passenger, meaning thereby they have only asserted that Since it is being used for hire and reward, therefore it is violation of terms and conditions. Violation is, my lords, condition A. The policy cover use of vehicle for any purpose other than clause A, hire and reward.
Higher, next one.
And next is, my lords, is not applicable from. But this is what is provided in section 140. Exclusion. That these are the grounds on which insurance company can disown the liability. So they have said it is for a hire and reward. And kindly come to the impugner. No evidence was left from the case. It is at paragraph 6 of the impugnement that insurance company has not produced any single witness or any documents in support of their case. Now, what I am arguing is that today, first of all, in view of order 14 rule 1, there was no issue. What is issue as per CPC? The material proposition of fact and law alleged by one party and denied by the other party. They have never denied. So trial court has rightly not framed any issue in this regard. Today they are arguing that this is the issue involved. You have never disowned that in terms of order 14 rule 1. The tribunal has correctly not framed any issue in this regard. Now kindly come to the judgment of this. But it's paragraph 14.
Paragraph 14.
No, 4 sorry. Because always the defense is we haven't received premium, therefore liability is disowned. This is discussed in this debate. According to clause E of section 2 of Contract Act, consideration spoke of that. I am not basically both side 2D Contract Act quoted. Similarly, clause E and F provides, clause E is quoted, promise is quoted, then paragraph 6. It is further provided by clause H that an agreement enforceable by law is contract. This is the pure Indian Contract Act. Now the contract of insurance, like any other contract, is concluded by offering acceptance. Normally, a liability under the contract of insurance would arise only on payment of premium if such payment was made a condition precedent to the insurance policy taking effect. But such a condition, which is intended for the benefit of insurer, can be waived by the insurance as laid down in the case of such and such, such and such. These are the principles relating to an ordinary contract of insurance, but the contract of insurance relating to motor vehicle has to be understood in the light of the various provisions contained in Motor Vehicles Act. In 1988, Chapter 11 of Motor Vehicle Act deals with the insurance of a motor vehicle against third-party risk. Section 146 inter alia provide as under. 146 necessity for insurance against third-party risk. That provision is quoted. 147.5 notwithstanding anything contained in any law for time to be forced, any insurer issuing a policy of insurance under this section shall be liable to indemnify the person or classes of person specified in the policy in respect of any liability which the policy purports to cover in a case that person or those classes of person. Next, section 149 casts a duty on the insurer to satisfy judgment and award against the persons insured in respect of third party risk. Subsection 1 of section 149, then the statute provision, then paragraph 8. The contract of insurance in respect of motor vehicle has therefore to be construed in the light of our provisions. Section 146(1) contains a prohibition on the use of motor vehicles without any insurance policy having been taken in accordance with Chapter 11 of the Motor Vehicle Act. The manifest object of this provision is to ensure that the third party who suffers injury due to use of the motor vehicle may be able to get damages from the owner of the vehicle, and recoverability of damage is not dependent on the financial condition or solvency of the driver of the vehicle who has caused the injuries. Now paragraph 11. Thus, any contract of insurance under Chapter 11 of Motor Vehicle Act contemplates that a third party who is not signatory or a party to the contract but is nevertheless protected by the contract. I am also not a party to the contract. I am not signed. I am not the insurer. Who is not signatory or a party to the contract of insurance but is nevertheless protected by the contract as pointed out by this court in the case of such and such, the rights of the third party to get indemnified can be extinguished only against the insurer of the vehicle. It is thus clear that the third party is not concerned and does not come into the picture at all in the matter of payment of premium. Whether the premium has been paid or not is not the concern of the third party, who is concerned with the fact that there is a policy issued in respect of vehicle involved and in accident, and it is on the basis of this policy that the claim can be maintained by the third party against the insurer. Then Madam 64VB is referred, and then Madam the Honorable Supreme Court has said that they are liable to pay compensation. And what is the fact of this case? Madam, in today morning 10 o'clock, an insurance policy is issued. Check is given to the insurance company. The fact of this case.
That is.
Yes. And what has happened? The check is honored at 4 o'clock, but accident happened at 2 o'clock. The insurance company has come up with a plea that we haven't received any policy. In my case, what they are taking defense, the insurer haven't taken the policy. Being an occupant, am I supposed to know that whether the premium was paid or not? And moreover, how they can argue this case in a first appeal without pleading, without evidence? Because issue also, my lords, in terms of Order 41 Rule 1 has to be denied by them. What they have denied, they haven't said in their written statement that in view of occupant you are denied. Rather, what they have said, occupant is not denied, but passenger is denied. If that is their contention, the onus comes on them to prove that what that particular material time the vehicle was being used as an hire and reward purpose, the premium was not paid to the passengers, and therefore the insurance company is not liable. And even in that case, I am entitled to get from the insurance company and then only the recovery be calculated for the. So they cannot change their stand, make out a new case. And Madam,
It is something that
Yes.
but the facts have been argued. Now only the judgments are to be relied upon.
Yes.
Now in this case, there is a one judgment of the Honorable Supreme Court.
What is your ground in the written statement?
What is my ground is only that this was an act liability policy. The occupants are not covered because no premium was paid, and as per the circular of the.
Just a minute. What have you insured?
I have insured the persons who are not the occupant in the vehicle. Any person who are outside the vehicle we have insured. That is third party liability.
What do you mean by third party?
Third party other than the owner and the insured. Now, in this case, as per the circular of the IRD, which has been dealt with by various judgments of the Honorable Supreme Court, that how it is distinguished, because in the act liability policy, there is nothing like that which will cover the occupants also. But in the package policy, which is called the comprehensive policy and it was solved, the occupants are covered. Now, this thing has been very clearly discussed in judgment of the Honorable Supreme Court. That is, there are few judgments of the Honorable Supreme Court I have referred to in this case, and other thing also. The first would be, in this case, reported in.
Just a minute. Yes, reported in.
That is reported in. Supreme Court, AIR 2009 Supreme Court 626, that is General Manager United India versus M. Lakshmi. Therefore, thereafter,
What has it helped? What is this?
now, in this case, Motor Vehicle Act 1988, liability of the insurer deceased over the pillion right of the insurance policy and act
Just
policy.
show me one thing. This judgment defines what is act policy.
Now, there are other judgments. Yes,
Then
I am coming to that. I am coming to that.
First, tell me what. Make me understand what is act policy.
The act
Where it has been defined.
Act policy is
Not for your submission, not from your submission, from any citations. What is act policy?
then I come to. Then in that case, then let us come to the judgment reported in Supreme with this Oriental Insurance versus Surendranath Lumba and others. That would be 2013 Supreme Court 483
Yeah.
area. The head note is as paragraph 14 to 16. Section 147 Act policy covers only third party and neither the pillion rider nor a co-passenger. Comprehensive / package policy, on the other hand, would cover pillion rider and co-passenger as well as the owner. Liability of the insurance company would depend upon the nature of the policy.
Party name?
Party name is Oriental Insurance Company versus Surendranath Lumba.
Surendranath Lumba.
Yes.
What is the spelling?
Surendra
Surendra.
Nath
Separate.
separate, everything is separate. Loomba, Lumba.
Yes.
This paragraph 14 to 16.
This is 2012. Volume 13 SCC. Page 792.
Yes.
Para
14 to 16.
60. But read that. Read that.
We have quoted in extenso to reiterate the legal position in the case at hand. The policy has not been brought on record. Here the policy is brought on record. The learned counsel for the appellate insurance company would submit that an act policy. The learned counsel for the respondent would seriously dispute and submit an extra premium might have been paid, or it may be a comprehensive package policy. When the certificate of insurance is filled, but the policy is not brought on record, only conveys that vehicle is insured. The nature of policy cannot discrete from the same. Thus, we dispose that to think that it would appropriate to remit the matter to the tribunal to enable the insurers to produce a policy and grant liberty to the parties to file additional document and also lead further evidence as advice we are accordingly. It needs no special emphasis to say that whether this insurance would be liable or not would depend upon the nature of the policy when it is brought on record and in a manner required by law. As far the quantum is concerned, though the number of grounds were heard, yet learned counsel for the parties did not easily address the same, and therefore we do not think it necessary to dwell upon the same and treat it as a proper comprehensive. In the result, this appeal preferred by the insurance may be allowed to the extent indicated above, and to that extent award is satisfied. Now, thereafter, let us come to the judgment of Honorable Supreme Court that is reported in Maharaj existing to Supreme Court, SCC, then 2008 Volume 7 SCC 428. That is Oriental Insurance versus Sudhakaran KV
2008.
8
2008.
Volume 7 SCC 428. Section 173, insurance company is not liable to indemnify the pillion rider over two-wheeler unless the requisite amount of premium is being paid to cover his risk pillion rider on the two-wheeler cannot be split in her part.
Just a minute. 2007, 2008, volume 7 SCC.
4 to 8.
Paragraphs.
Unfortunately, judgment which I am reading, there is no specific paragraph, but head note is there. By order of current, I read that.
Come from the paragraphs.
Paragraph 7. Before embarking on the rival contention.
This particularly, if you come to this, you are relying on this policy also.
Yes.
What is this policy?
This is act
private car policy, a liability only.
Act liability only.
Policy, private car policy, a liability only. What does it mean?
Act liability. Act liability.
What is the policy?
Policy is actually two parts.
It doesn't say so. It says private car policy, a liability only. What does it mean?
There is some, because of the thing that it could not have been printed properly, the Xerox copy would not have been appeared properly. But it is the policy which I am having also.
That's why where is in my person. It appears that only one page of insurance policy is included. Right now I have got the policy schedule. This policy schedule states so it's a comprehensive because premium is paid for EP basic, third party basic, then third party property and damages and compulsory PA and owner driver coverage. It has become comprehensive. Can Mr. Nath's client file an affidavit?
Yes, we file an affidavit.
That it's not a policy, a comprehensive policy.
But a package policy.
And therefore they have not taken this stand in their written statement.
But act policy is something different. Act policy does not include. Then I am coming to that. Let me explain how this thing has been explained in other judgments. Let me explain. Let me explain how this thing has come. The act policy and the package policy has been explained in various other judgments also. Let me refer both judgments.
Yes.
I wanted to give the judgment which was from the earlier. Now the latest judgment by kindly be seen. The latest judgment by kindly be seen. That is 2018 volume 15 SCC 189.
2000.
2018 volume 15 SCC 189.
2018
volume 15 SCC page 189 Jharkhand Singh.
volume 15 volume 15
89 189 SCC 89 189. Party's name is Jharkhand Singh alias Jagdev Singh versus Sanjeev Kumar and others. Now I read that it's this very small judgment. Of course, there is one judgment of the Honorable Madras High Court, that is the recent one, that has discussed all these things. Of course, that is not a binding upon you, but the principles which have been.
Yes, what is this say?
Madras High Court.
Yes, 2015 18 180 2018 15 189.
Yes, 189.
Yes.
Yes. In this appeal, the special leave by the appellant calls in the question of propriety of the order dated 18th August 2018 passed by High Court of Punjab and Haryana, Chandigarh, in FAO number 1684 of 8, where the High Court has dislodged the finding of the tribunal and made owner liable for enhancing the amount of compensation, insurer has been absolved on the ground that the defendant was a gratuitous person in the car. It is submitted by Mr. Jagunandan Bansal, learned counsel, appearing on behalf of the controversy, that the controversy is covered by two judge-bench decision of National Insurance Company vs. Balakrishnan, reported in 2013, volume 1, SCC, page 73. I will be relying on this separate because this has explained everything. It is extremely important to note that till December 2006, the Tariff Advisory Committee and thereafter from 1st January 2007, IRDA functioned as the statutory regulatory authorities, and they are entitled to fix the tariff as well as the terms and conditions of the policy of all the insurance companies. The High Court has issued notice to Tariff Advisory Committee and the IRDA to explain the factual position as regards of the liability of the insurance companies in respect of occupant of the private car under comprehensive/package policy. Before the High Court, the competent authority IRD has stated on 22nd June 1996 that Tariff Advisory Committee has issued instruction to all insurance companies to cover a pillion riders, scooter, motorcycle under comprehensive policy, and the said position continues in both till date. It is also admitted that comprehensive policy is presently called package policy, and admitted position that the decision would show that earlier circular stated 18th March 1978 and where 2nd June 1986 continue to be valid and effective. In all the insurance companies are bound to pay compensation in respect of the liability towards occupant of the car under the comprehensive package policy, in irrespective of the terms and conditions of the containing the policy. The competent authority of the IRDA was also examined before the High Court, who stated that the circular dated 18th March 1978 and 2nd June 1986 of the Tariff Advisory Committee was incorporated in the Indian Motor Tariff effect from 1st July 2002. They continue to be operative and binding on the insurance company. Because of the aforesaid factual position, the circulars dated 16th November 2019 and 3rd December 2019, they have been produced in court of which were issued. It would also worthy to know that High Court, after preparing the individual circulars issued by various insurance companies, eventually stated that thus, in view of the aforesaid, it is clear that the comprehensive package policy of a two-wheeler covers the pillion rider. Comprehensive package policy of private car covers the occupants, where the vehicle is covered under the comprehensive package policy. There is no need of the motor vehicle claims tribunal to go into the question whether the insurance company is liable to compensate for the death of injury of the pillion rider or on a two-wheeler or occupants in a private car. In fact, in view of the TSC's directive and code of IRDA, such plea is not permissible or to not be realized by you. For instance, it was the present case. In view of the aforesaid factual position, there is no scintilla of doubt that comprehensive/package policy would cover the liability of the insurer for the payment of compensation of occupant car. There is no cavil that an act policy stands in a different footing from a comprehensive package policy. Thus, as the circular made, the position very clear of that IRDA, which is presently statutory authority, has recommended the insurance company stating that the comprehensive package policy would cover the liability and there cannot be any dispute in this regard. We may hasten to clarify that earlier pronouncements were rendered in respect of act policy was admitted cannot be a third party risk of procurement in the car, but if the policy is a comprehensive package policy, the liability would be covered. These aspects were not noticed by the Bhagyalakshmi Supra case. Therefore, the matter was referred to a larger bench. We are disposed to think that there is no necessity to refer the present matter to larger bench and IRDA, which is presently the statutory authority, has clarified the position using circulars which have been produced in the judgment of Delhi High Court and produced in the same. In view of the aforesaid, we think it appropriate to set aside the judgment ordered by the High Court and remit the matter for consideration whether the policy is comprehensive policy or exclusively a fact policy. Such a consideration shall pass recent order needless to say if any other conditions available, the insured will be at liberty to raise the same before the honorable judge. So this is the Jagdar Singh's case, ladies and gentlemen. Now let us come to the Balakrishnan case, which I will refer to. The Balakrishnan citation I have given over
13-1-373, 731.
Balakrishnan is 13-1 SCC 731.
13-1-731.
Yes. Balakrishnan has been was the base. On the basis of the Balakrishnan, this judgment was passed. Thereafter, taking into account all the judgments of various high courts and normal Supreme Court, the Madras High Court, in a recent judgment, and in earlier judgment also, has held that in this case, where there is not a package policy, the insurance liability of the insurance company would not be covered. So other judgments I will be relying upon.
Mr. Counsel, the original policy is not on record.
No, but it's only Xerox.
So why
copy.
not these two judgments be applied and the matter be remitted to the court below for deciding?
But it's my contention is that it's whatever has to be decided, I am here before this honorable court because while the quantum of loss has to be paid by insurance company. Even if it is not covered, that
No,
can be
no, Mr. Counsel, both the cases, your appeal also,
in my appeal also.
that has to be
Let-
also remanded.
Let my
Because what would be the actual quantum of compensation? Because the claim was made in respect of two, but it was allowed in respect of one, nothing has been said in respect of the other.
Yes.
So why not both entire award be remanded with fresh two issues?
that can be done.
That is the only way.
That can be done. And before that, that's my submission is that's let it be come on this because it's not an act on the policy. They have never said so.
They will bring it on record.
But it's
Their
that-
policy will bring on the
my
policy will
submission
say,
is-
Mr. Counsel, if they say it is an act only policy,
Never said in the written statement. Never said in the written statement.
why do you interrupt? Answer the listen to the question first. If they say it is a comprehensive policy or it's an act only policy and they produce the policy, if the policy says contrary to what they have stated, which will be more, what will be binding upon the court? The policy or what they stated?
That's my
Just tell me the policy or the statement?
their policy.
Policy. So
They
the
not
policy cannot be
allowed
brought.
to giving them a fresh opportunity which they have
Heard the counsel
already
for the
lost.
appellant, heard the counsel for the respondents.
But meanwhile, the amount what they have deposited and is that much given. to
Yes,
the-
that will be allowed to be withdrawn.
But in that case, because owner is appearing,
Where is the, just a minute, where is the amount deposited?
lower court.
No, that will be kept in a fixed deposit account.
Yes, that can be done. That order can be done. We have got the chance.
And the matter to be decided within 3 months.
Yes.
And here, the appeal number, heard the counsel for the appellant in both and the respondents in both the cases. The appeal number AMA 622 of 2016 has been filed by the appellants, claimants, praying for enhancement of the compensation. Whereas the appeal number 34 of 2016 has been filed by the insurance company challenging their liability to pay the amount of compensation. First off. Both the appeals arises out of a same award dated so and so passed by so and so in case number so and so. That's the next one. The counsel for the owner of the vehicle is also present. Next one. After reading the arguments, this court feels that the case should be remanded to the tribunal for deciding two vital issues which has not been decided by the tribunal. Next one. The counsel appearing on behalf of the appellant insurance company in case number so and so.
That's my solution is my word is regarding on two issues whether it's an act only or comprehensive policy and number two, what is the compensation required for a deceased minor son. Then what has to be the compensation paid to father. That question attains finality once my lords will say that I will be working on it. So that question may also be left open.
Just a minute. Can you The insurance company in MA number 34 of 2016 submits that the policy by which the vehicle was covered is an act only inverted comma, act only policy and was not a comprehensive policy. He submits that when the policy, it is his contention that since the policy is not comprehensive, the occupants of the vehicle is not covered by the policy. First up. In support of his contention, he relies upon the judgment of the Honorable Supreme Court in the case of so-and-so versus so-and-so, 2013, Volume 1, SCC 731, 2018, Volume 15, SCC 189. Then it comes for the claimants submits that in their written statement nowhere the plea has been taken that the policy was act only policy. First up. It is, as per him, it is the case of the insurance company that the vehicle was being used for hire and reward. But surprisingly, in support of their contention, the insurance company has not reduced any evidence. He submits that now the insurance company cannot take the plea that the policy was act only policy. Next one.
One more. No premium has been paid to the passengers.
Full stop. To appreciate this issue, I have gone through Exhibit 2, which is the only document of record. Exhibit 2 is not the policy. This is the certificate of insurance. From the said certificate of insurance, one cannot decipher that it was an act only policy or was a comprehensive package policy. Whether the passengers were covered or not, it is also not mentioned in the said certificate. It only mentions that it is a policy for private car. It only mentions as follows within inverted comma, private car policy A liability only. What was covered, who at all were covered, and whether the passengers were covered or not has not been mentioned in the entire in the certificate of insurance. In paragraph 27 of the judgment of the Honorable Supreme Court reported in 2013-1, 731, on the facts of that case which the Honorable Supreme Court was considering. After considering the case in hand, the Honorable Supreme Court had held paragraph 27 quote. In this case also, I find that there is nothing in the order of the tribunal. There is no discussion in the order of the tribunal as regards to the policy, as whether it's an act only policy or the comprehensive policy. Even if a plea specifically has not been taken in the pleadings as to whether the policy is act only or comprehensive, it is the duty of the court to come to a finding after going through the policy as to whether the policy is act only or liability, because the same will have a huge impact on the judgments. First, a pleading cannot be contrary to the terms of a contract. First, insurance is the terms of a contract. Full stop. Insurance is a contract. Full stop. Thus, the ultimately the terms of the contract would govern the judgment, not the pleadings. Full stop. In these type of cases, where terms of the contract is to be you will have a final say on the judgment, no matter what is mentioned in the pleadings, will not govern or override the terms of the contract. Full stop. That being so, even if in the pleadings nothing has been mentioned about the policy, whether it is act-only policy or a comprehensive, it is the duty of the tribunal to find out as to what is whether the policy is act-only or comprehensive. First time. The tribunal in this instant case has not mentioned, has not discussed the aforesaid fact, nor arrived at a finding, any finding. First time. Be it noted that to arrive at the aforesaid finding, the policy has to be on record. Surprisingly, the policy was not on record in this case. Thus, I think it proper to remand this case to the tribunal to decide the issue as to whether the policy was an act-only policy or a comprehensive policy, and whether this say covers the passenger of the vehicle or not. In the appeal preferred by the appellants, they are challenging the quantum. First, one matter is one fact is apparent, that the claim application was made. Claim application was filed claiming compensation for the death of the father and son. The tribunal assessed compensation in respect of for the death of the father, but has not paid any amount in respect of the son, not discussed as to what would be the compensation in case of death of the son. First. Considering the aforesaid fact also, since the matter is being remanded to the tribunal is also directed to consider as to directed to compute the compensation which should be granted to the claimant as a result of death of the son. Mr. Sinha, so far as the father is concerned, you have no grievance.
No, for father also we have in this appeal read that the amount has to be enhanced in view of Sarla Government purpose.
Further, it is the case of the claimants that in view of the Sarla Verma's judgments and the judgment of the Pranay Shetty, reported in so and so, the compensation amount paid to the compensation assessed in respect of the death of the father is also to be enhanced. Since this court is remanding the matter to the tribunal will also decide the amount of compensation which needs to be paid to the father and son, paid in respect of death of father and son, in lieu of. Thus, full stop. The parties will be, if the parties will be at liberty to adduce fresh evidence, but it is made clear that the insurance company will bring on record the entire policy document of the vehicle.
Allow the policy schedule and documents.
Policy documents. Or the entire policy documents in respect of the vehicle in question. First up, it is expected that the Since all the parties have appeared in this appeal, they will cooperate in early disposal of the case before the tribunal. First up, it is expected that within 4 months from the date of receipt of the copy of this order, the tribunal will try to dispose of this case.
So the statutory amount which we have deposited.
First up,
That's my prayer is I have filed, I give to release of amount. The claimants are widow, minor son, and a widow mother. But it's at least some amount there because ultimately I will get
In that case,
since the appeal filed by the insurance company is limited to the liability, limited to their liability, which they are denying, and the appeal preferred by the appellate is in respect of enhancement of compensation, one fact, the compensation, I am of the opinion that the quantum which has been assessed and has been assessed in award dated so and so is the least which the claimants can get. Further, if the submission of the insurance company is accepted, then at best they can get a right to recover the amount.
But so far the right of recovery is concerned, Manoj.
That being so,
When there is no liability, they have not undertaking the liability, then the right of recovery will not arise at all, because in that case,
and the fact that the vehicle was insured, the vehicle was insured, and the fact that the vehicle was insured, at best the right of recovery can be granted to the
but in
insurance
that case,
company.
my submission,
At best, the vehicle was insured, the at best right of recovery can be granted to the insurance company by applying the theory of pay and recover, I direct the tribunal to disburse the entire amount which has been kept in deposit in terms of award dated so and so to the claimants.
the statutory amount will be recovered.
First of next file, the statutory amount deposited before this court should be refunded to the insurance company.
So the other two cases,
What is the other two cases?
they same out of the same
Who died?
one another person. What I
Who was also a passenger.
yes, he was,
He was also, but he's not with me.
but he's not. What I
Okay, the other two cases, Maliko, detached, fresh notice to the claimants.
fresh notice though, but in so far in the item number 622, no, this item number 399. Two has died, one has left the place of
Nikita, next to detached, listed under the heading for orders after summer vacations. The appellants, Mr. Alokla submits that one of the who is dead.
but as per the office notice, two
He submits that he will take appropriate steps. Are you for? Which case? Is it disposed of?
Yes.
It is disposed of.
Under the heading of order, serial number 5, FA number 560 of 70, Mr. Arvind Kumar Lal, for appellate, Mr. Ashutosh Anand, for respondent.
In this case, my lord, since I have given my no objection certificate to the applicant, my name is
Nikita, who is appearing?
I am appealing.
You are Mr. Verma.
Om Prakash Singh.
Huh?
In person.
Who is Mr. You are in person, you are appearing.
Yes.
Who are you?
I am Samir Ramanaj, the advocate for the.
How can you assist a person who is in, how can I advocate assist a person who is appearing in person?
I
He is in person, when you appear in person.
Okay. My name is.
Let the name of all the advocates be deleted. Have you withdrawn the wakalatnama which you had given to him?
No, no, no.
Then? Are you withdrawing it? Are you withdrawing the wakalatnama which you had given to him?
No, no. Yes, I am not specialized in this case.
What do you mean to say? What do you intend to say rather? If you want to, you have every right to argue in person. But before arguing in person, you had given an wakalat, you have signed the wakalatnama in favor of a lawyer. Have you withdrawn it?
एक्सीडेंट के बाद हमारा कई बार लगातार तबीयत खराब
This is not the question which I am putting to you. समझ में नहीं आ रहा तो हम हिंदी में बोल रहे हैं. आप वकालतनामा दिए थे कोई वकील को, वकालतनामा अभी भी पेंडिंग है, उसको विथड्रॉ किए हैं इन पर्सन अपीयर करने का पहले. अगर आप इन पर्सन अपीयर कर सकते उसमें कोई दिक्कत नहीं है. उसका आगे आप इनका वकालतनामा विथड्रॉ कीजिए. आप क्या चाहते हैं? इन पर्सन अपीयर करना चाहते हैं?
नहीं नहीं, ये अपीयर कर रहे हैं.
तो आप बैठिए. The name of Mr. Arvind Kumar Lal be struck off from the cause list as he has given no objection and Mr. Samir Verma advocate has appeared. Where is Ashutosh Anand?
Lordship, I'm appearing on behalf of Mr. Ashutosh Anand. He is for respondent number 2, Lordship. Respondent number 1 has not appeared yet.
Who is the owner? Is there? Respondent number 1 is the?
Respondent number 1 has not filed a wakalatnama.
Who is respondent number 1?
Ajay Kumar Sahu, Lordship.
Who is he? What is his status?
Registered
The right to recovery granted in this case. Right to recovery granted.
From the
Show me.
From the owner.
Where is it?
Memo of the lordship.
No, no. Read from the judgment. Show me from the judgment where the right to recovery is included.
Ordered lordship at page 190 lordship. That opposite
Who is
party.
Augustine Kujur?
He has subsequently purchased the vehicle after the accident.
After the accident has taken place.
That is very apparent from page number 20 lordship of the judgment lordship.
What is the date of the accident, Mr. Counsel?
The date of the accident is lordship 24
Number
24/4/2012 lordship. Date of accident.
A number?
Is for substitution of
Which one? Pay IA number?
IA number
1436. Who is that?
1436 lordship for substitution
Of?
of the registered owner that India's dad by his son.
Ajay Sahu. Leaving behind?
His son Ritesh Kumar.
Where have you stated? When did he die? When did he die?
As per that office note,
No, this note has informed that he is dead.
he is dead
But
last 3 years. He has died.
we get the issue notice to the proposed legal heir of respondent number 1. We issue notice to Ritesh Kumar Sahu, son of Ajay Kumar Sahu, resident of so and so, paragraph 7 of the IA, who happens to be the proposed legal heir of respondent number 1. And is sought to be substituted in this petition. Whose substitution is sought for in this petition? Some notice to be issued, filed within
2 weeks.
within 2 weeks by registered and ordinary. There is this case immediately after service of the notice. This is a case of injury.
Lordship. He has been
And it has been dismissed or allowed? Allowed. And who is directed to pay?
That to pay the subsequent
The subsequent owner. Who is the subsequent owner? He has also not appeared.
He has not.
Notice served upon the subsequent owner.
No, Lordship. The address is insufficient, Lordship. The address mentioned here is of Khilari 2. Only as Khilari 2.
You insured who? It was a third party insurance. It was a third party insurance or it was a comprehensive insurance? On the date of accident, the vehicle was insured. Vehicle was not insured.
Subsequently, Lordship, during the release of the vehicle,
After release of the vehicle.
yeah, when they reach the court for release of the vehicle, then the vehicle was insured in the name of Ajay Kumar Saab. No, insurance before release. Before release, Ajay Kumar Saab के नाम पे इंश्योरेंस हुआ Lordship. Thereafter he was released. तो रिलीज नहीं हुआ, उसके बाद फिर अजय कुमार साहब ने ट्रांसफर कर दिया Lordship इनको. सब्सिक्वेंटली 12 दिन बाद एक्सीडेंट के 12 दिन आफ्टर 12 days when into the accident.
Take steps, let him appear.
I just want to show some dates, Your Lordship. Acts first.
Decide who will argue this case. I will not allow this. If you want to argue, you can argue. No problem.
Serial number 6, MN number 564 or 70, Mr. Prashant Vidyarthi for appellant, Mr. Alok for respondent.
Very output. The picture of the copy was given to me, but I have not located copy in my office level. So let it come after my location. You will find it arrange a copy.
I served the copy, but
This is what?
The police for the
Enhancement.
डिफेंस
So
मिनिस्ट्री
it is a union of India.
यूनिफिड कंट्रीब्यूटरी नेग्लिजेंस में दिया गया है बट आवर कंडीशन इज दैट नो फाइट
Who are you?
यूनियन ऑफ इंडिया मिस्टर पीपल
No, no. Union of India, you are the owner of the vehicle.
यूनियन ऑफ इंडिया वन ऑफ द आर्मी vehicle was involved.
And you are saying that there was no fault of you. You're having
our specific contention was that it has come in the FIR also.
Yes.
Not an expert, I can be.
And he was a national insurance company.
But unfortunately, I could not locate the file, therefore I could not say anything. But I was looking for this file yesterday because we got the list at the nick of the time. It was served on 20th, but I'll again.
It's a death case. It's a death case.
Yes, please. But I'm not aware of anything because we could not locate the file, therefore.
But why it has been listed in
It was given
the limitation petition?
limitation.
195 days. I mean,
The delay may be controlled.
delay control.
Delay may be
For
controlled.
of so and so is this case under the for admission.
And I'll make a request person because I cannot get it. Away.
Serial number 7, MN number 615 of 70. Mr. Amit Kumar, Mr. Neeraj Nayan Mishra.
Yes.
First, your limitation is there. I think part 22 days.
122 days. Where is the respondent?
Part 2 who's got the responsibility?
Who is appealing 1 to 5? 1 to 4? Who is appealing?
I am for the insurance company.
You get to I number 9971 of 2017, 22 days delay. Though the respondent number 1 to 4 has appeared, the filing of Alatama, but no one is present today. No lawyer is present today. Also, the counsel for the appellant submits that the delay was unintentional, so it's a paragraph so delay control otherwise for admission. What is your ground in this appeal? What is your ground?
False claim of insurance. False. Yeah, we need to go to call. I have mentioned in my ground also.
What is the false claim?
Actually, from what happened, the accident took place around 8/9/2011.
8/9/2011.
9/2011.
Yes.
And therefore, that he remained for he supposed to be tried for 15 days till he was died 23/9/2011 for 15 months. And thereafter, that he died on 8/5/2012 after 8 months. Apart from this one, the most relevant point that it has come that the injury that had caused to the person who died is due to only falling on a iron rod or something without iron silicate. So, but it has come. They are claiming on the basis that it was due to the accident. That is not item.
You can say this is not a death case, it may be a case of injury. First, it can be a case of injury.
Yes. That has not. There will be event for the concern.
Another for admission is immediate for the lower records.
Serial number 8, MN number 648 of 70, Mr. DC Gold.
But at the ground of Mr. DC,
Where is he?
Not because some medical reason has gone. I could not say, I could not be called proper to say, but he has gone. He was supposed to come. Will he come after vacation?
On the request of Mr. DC Ghost, this case is adjourned for 1 week.
After vacation. After
1 week,
And then item number 45 also.
let it be taken up. 250 days the first schedule, I don't think so. We can take up any other matter.
We can also be assured that
I don't think so. I think that it's 250, there is this first appeal which has been heard. I don't think so any matter can be taken.
good enough for that case.
It is for final hearing. Yes, next.
Serial number 9, MN number 327 of 80, Mr. Ashutosh Haman, for appearance, Mr. Suraj Gupta, Mr. Prashant Thakur, for respondent.
Mr. Ashton is on legs in Lordship in court number 20.
With what?
In court number 20 is on legs.
What is this?
There is an IA for limitation in Lordship.
What is
49
your ground? What is your ground in this appeal? What is the ground in this appeal?
One of the grounds is, Your Lordship, that the deceased was riding his bicycle, Your Lordship. And the accident occurred on account of the deployment and then there is appellant cannot be assigned with the responsibility.
You are praying for an apportionment on the ground of contributory negligence of the deceased. What evidence have you get? What evidence have you led? Did you need any evidence?
I apologize, Your Lordship, I am not prepared with the case.
Call him. Call him.
Second one.
Call him 215.
Yes.
First, yes, scoop water.
Serial number 10, Cause Appeal 427 of 18, Mr. Seth Kallam or appellant, Mr. Mangal and Sinha for respondent.
Lordship, there are 4 IAs in this appeal here, Lordship.
Yes.
Lordship, there are 4 IAs here, Lordship.
Yes.
IA number 11808 of 2019 is for the continuation of delay in filing of the appeal petition, Your Lordship. There is a delay of 371 days in filing of the appeal, Your Lordship. The ground is with regards to the medical unfitment of the appellant, Your Lordship. I have annexed the medical reports also, Your Lordship. Earlier notices were also issued to the respondents, Your Lordship. There is one other IA, Your Lordship, 820 of 2020, which is for stay. Lordship, on that itself, Your Lordship, I had mentioned this matter for early listing, Your Lordship. Lordship, the urgency as to why I am pressing this application for stay, Your Lordship, is because, Your Lordship, now the delivery opposition is going to be issued against in regards to execution of the final decree that has been prepared, Your Lordship. And if the Lordship,
It's a partition suit.
it's a partition suit. It's a partition suit, Your Lordship, wherein the exhibits that were filed were in form of RS Khatian, wherein, Your Lordship, it was already demarcated that the ancestors, the properties was divided. And even in the plain, it has been mentioned that there was some division, but details thereof were not told. And in the impugn judgment, Your Lordship.
Does it mean that all division will amount to partition?
Lordship, my specific case and the case of the respondents, other defendants were all the same, that partition had already been effected between the parties. And there is nothing left to be partitioned.
So that was the issue definitely?
Lordship, that was the issue, Your Lordship, and if Your Lordship will have a look at the judgment that has been passed, Your Lordship, page 27 onwards.
Where is the respondent?
Lordship.
No one has appeared.
They have appeared, Your Lordship. They have appeared. They'll be wanting not to appear in this appeal, Your Lordship. Make sure that delivery operation is effected. That is their whole intention.
Who is appearing?
I'm not aware as to where.
On behalf of whom?
Lordship, on behalf of the respondents, Lordship, that is recorded in the order also.
Who are three?
All the respondents have appeared, Your Lordship. Even the subsequent respondents have now
It
appeared.
was listed on the last day.
It was listed Wednesday, Your Lordship, on online mode. Then Your Lordship was pleased to fix it for today, Your Lordship, for physical hearing.
Served through a daughter refused to accept. On whose behalf Manranjan and Sinha is appearing?
Lordship, now he is appearing on behalf of all. even I have filed an IA for substitution of respondent, Your Lordship. One of the respondent were died. Even on behalf of the substituted heirs, Your Lordship, he has filed an affidavit to that effect.
Where is your order sheet showing that the delivery of position will be affected?
Lordship, that order sheet is not there. That order sheet is not there. I have filed the notices that we issued in the
The counsel
execution
for
case.
the appellant submits that in this case, the delivery of position will be affected after preparation of the final.
It has been prepared. Final decree is already prepared.
Affected as the final decree is already prepared. What's up? No one appears on behalf of the respondent, though a name of counsel is appearing in the cause list. So considering his submission, let this case after vacation. What's up? Be noted that the delivery of possession pursuant to the final decree, delivery of possession in respect to the final, pursuant to the final decree, which has been prepared consequence to the judgments dated, pursuant to the judgment, final judgment passed in partition suit number 84 of 2009 by Senior Judge,
Civil Judge Senior Division.
Senior Division 7, Ranchi. Will not be given effect to. Okay. Again, is this case on 14th of June
Obliged.
under the refer orders.
Obliged.
But we can no one appears on behalf of respondent. लिखे हैं कि नहीं? क्या लिखा? उसके ऊपर क्या दिया? शुरू से बोलिए, शुरू से पढ़िए, शुरू से पढ़िए। तो लिखिए नो वन appears on behalf of the respondent. No one appears on behalf of the respondent लिखा है ना? Though the name of the lawyer appears, full stop लिखिए. Counsel for the appellant submits that they are deliberately not appearing as they want that position be delivered in their favor.
Obliged.
Next.
Serial number 11, serial number 12, serial number 30, MA number 436 of 80, with MA number 451 of 80, with MA number 452 of 80.
Lordship, in this case also I'm praying for passport on behalf of passport.
The last case has been assigned. Where is the title? Where is the title on it? This case has been listed before me.
The last one was title
4/5/2022. There is an order to list this case along with email number 452 of 2018. 452 has already been assigned to another bench. Why today the case is listed before this bench? Why the case is listed before this bench?
last one
436 years. List this case along with email number 452 of 2018 and email number 451 of 2018. So this case was directed to be listed with this, and this case is before Another bench. So this should have been listed before another bench. This section doesn't understand implications of orders. Place it in my office. Call the registrar list. And the section officers. Or the same. Section officer and the deleter. Tell them to be there. In my chamber just now. Yes, next.
Serial number 40, MA number 441 of 80, Mr. Ashutosh Anand.
Lordship, in this case also I am paying for a password on behalf of Mr. Ashok. Let the matter be taken up at 2:15.
This is for what purpose?
For limitation, Your Lordship.
Accidents. For enhancement.
Yes.
So can it be resolved?
Your Lordship, as per my understanding,
In
Your
that
Lordship,
case-
40,000 is also not given, Your Lordship, then 40,000 I give. But
In that case,
yeah. Apparently 56 lakhs 50 is 43,692 already paid, Your Lordship.
no, so he's claiming on what ground?
Is claiming on the salary slip, Your Lordship.
What is the salary slip?
Salary slip, Your Lordship, page 10 of the judgment, Your Lordship.
Page 10.
Yes, sir. Last line.
10, yes.
Last line. Further, from perusal of document 13, his last salary drawn for the month of July 13 before his death in the month of August 13 from Jindal Estate Nayatna be proved. As per this document, after compulsory deduction, his net salary was 40,540. I said on this basis the compensation is given.
The compensation has been calculated on what basis? What was the salary?
Yes, Your Lordship.
What was the salary assessed?
Then NCR will be
541. It should be on the basis of 541.
yes.
Now 501. What is wrong in it?
Total income was in the 541.
Yes, 501.
Yes,
What
sir.
is considered on 501
Yes.
662?
Yes. And only lacking Your
What is the delay?
Here is 161 days.
Delay control, so I is 101. Is this case under the heading for admission or for the local reports?
Serial number 50, MA number 453 of 80, Mr. Ashutosh Anand.
Yes.
In this case also I am paying for it.
What is your prayer? So you are in the chamber of Mr. Ashutosh Anand,
Lordship.
and you don't even have the time to go through the files also, and you don't have the file also.
Lordship,
He is on legs. Okay, very good. He is on legs.
apologize, Lordship.
Then where is the file?
Lordship, I think it's
And you know very well that he will not be appearing. When did you come to know that he will not be appearing when he has instructed you to take time?
half an hour.
So in half an hour you were sitting here.
Lordship, back-to-back cases were listed, so I was just standing here.
So you are standing here, you could have gone through the files also, why it has been listed. For orders. And more so when you know that Mr. Ashutosh Anand will not be, he is in legs, busy in legs. This is the sense of seriousness you juniors are showing. And I am not calling you a junior also. How many years of practice you have put in?
10 years.
So, the constitution says that minimum of 10 years is necessary for
Me, Judge.
so you are not a rank junior, then but your attitude is like a 3 months entry in the bar, entrant in the bar. This is for orders also. And if you say that your senior, Mr. Ashutosh Anand, has directed you to only take time, then having a lawyer having a 10 years standing in the bar should refuse that instruction. To obey that instruction.
I apologize, Your Lordship, but this morning, Your Lordship, 2 of our juniors couldn't come to the
So you
chamber.
could have
So all of a
taken
sudden-
the file and at least gone through that. You should go through the file and say that why it has been listed for orders.
Yes.
He's only praying for time. How much time you need? See,
Lordship, let the matter be posted for 2:15, Lordship. They made the assist.
your memo of appeal is of 9 pages and your order sheet is of 12 pages. Adjournments. This is the state of affairs.
I'm just praying, Your Lordship, that the matter may be taken up this.
But more than 215 days.
Serial number 16 with serial number 17, MN number 475 of 18 with MN number 604 of 18. Mr. Alok Lal for appealing in first case, Mr. Abhinal for appealing in second case.
What is the ground, Mr. Lal? Why it has been listed under the heading for
But perhaps for the limitation in this case, 155 days.
156 days. But the other one?
225 days.
225. Both I am condoning. Delay condoning.
But perhaps the owner is not appearing in this case. Notices were served.
It will come under the heading for admission. Delay condone. Both the I is allowed under the heading for admission or for the lower court records.
Okay.
Serial number 18, MN number 476 of 18, Mr. T.K. Sinha, Mr. Devesh Krishna for appealing.
No one appears. Adjourned to be listed after application.
Serial number 19, MN number 522 of 18, Mr. Alok Lal.
But in this case, the notices were issued. R2 has been received by son, R received returned by son, 1 का by son, 2 and 4 by brother, 3 is valid.
Owner or 1 received by son.
By son, 2 and 4 by brother.
3 valid.
3 valid, and 5 to 7 only is a language foreign to me.
2, 3, 4.
5 to 7 is a language foreign to me.
5 to 7?
Language is foreign to me, therefore I could not understand. Whereas my lord may be able to.
7.
My lord may be able to read.
This one. This is 5 to 7.
It's foreign language.
5. Who is 5? Give me the name.
5 is. Five is registered owner.
Name.
There's Tanumita Paul. Tanumita Paul. 6 is the under the authority of owner was driving the vehicle, and 7 is the driver. So driver is driver.
Let me read that.
Seven is the driver.
Name.
Name is Tirtha Pundu.
Huh?
Tirtha Pundu.
Tirtha.
Tirtha, Tirtha. Tirtha Pundu. As it appears from the award.
Received by Uncle Atonu Kundu. Joint family. Is the driver?
He's the driver. 7 is the driver.
No relief has been sought for against.
The driver usually.
Since no relief has been sought for against the driver of the vehicle, no notice, fresh notice needs to be issued to respondent number 7. Look here. Who is this Tanimita Paul?
She is the registered owner, and 6 is the person who was under the authority of the registered owner. He was flying the vehicle.
From the process server's report, which is in Bengali. After going through the process server's report dated 20 February 22, 2020, which is in Bengali, I find that respondent number 5, Tanumita Paul, was not present in the house when the process server went to serve the notice. But Sapriya's mentioned that in absence of respondent number 5, the notice has been received by her husband, Jaganmoy Paul, alias Jagannath. Thus the notice is validly served. Who is Atonu Kundu?
Atonu Kundu is the person who under the authority of 5, he was getting the bus being driven, because
he is the manager in charge.
He is in charge.
In charge. Atonu Kundu. He is most probably related to the order?
Well, from this award, we could not connect it because there is nothing which is similar. Only the place of their district is the same and nothing beyond that.
Okay, so far as respondent number 6 is concerned, from the office notes, from the process service report dated 20/2/2020, which is in Bengali, it is evident that the respondent Otonno Kundu has received the notice. Plus the notice is validly served on
All the parties.
Respondent, sir, next one. Plus I find that the notice is validly served upon. Now, there's a limitation.
It's 26 days as per my report. Okay, calculate.
The 26 day post in spite of service of notice, no lawyer appears on behalf of the respondents. Good start. So what are the claimants? Mr.
Claimants also the one with notice are validly served. One is the by son, 2 and 4.
So far as notices to 1 to 4 is concerned, 1 to 4 is concerned, the notice in respect of 1 has been received by the son. There is notice upon respondent number 2 and 4 has been received by the younger brother, and notice upon respondent number 3 has been validly served. Last minute here. In spite of valid service of notice, no one is appearing on behalf of the respondents. First up, this application has been filed to condone a delay of 26 days. First up, after going through paragraph so and so, I find that sufficient ground has been shown to condone the delay. Delay control. Is this case another hearing for admission? Call for NCR.
Serial number 20, MI number 524 of 18, Mr. S.K. Verma, Ms. Lakshmi Kumari.
Lordship, I pray for not today. Dr. Varis is not out of station.
Who is gone out of station?
Dr. Varis.
Why this case has been listed today?
Limitation. Lordship, no delay on 159 days.
What is the ground? What is the ground to condone the delay? Why there was a delay? What have you stated in the petition?
Appellant is the own case.
Which paragraph? Where have you stated?
Para 1 to 30.
Read.
Lordship, file नहीं है.
हाँ?
File नहीं है Lordship.
फाइल नहीं है तो सीधा शुरू में ही बोल दीजिएगा फाइल नहीं है, हम I am unable to assess this one. Issue notice to the respondents on the limitation matter. Ordinary process requisites 6 weeks.
Serial number 21, MI number 534 of 18, Mr. Sandeep Verma. Serial number 22, MI number 535 of 18, Ms. Raj Lakshmi Mishra, Neetu Singh.
I'm for respondent number 1.
What is it?
I'm for respondent number 1.
Yes.
Delay of 116 days.
Senior advocate Mr. Rajiv Sharma has appeared and has prayed to condone a delay of 115 days. 116 days. He has not allowed his assisting counsel also to appear before this court, placing an application, praying for seeking a delay of 115 days.
I asked you.
But considering paragraph so and so of the IA, the delay is condoned with the cost imposed upon Mr. Rajiv Sharma, rupees 1,000 rupees to be immediately handed over to his assisting counsel.
मिलॉर्ड ये लिखवा नहीं है हम दे देंगे लिखवा दे हाँ
What is your name?
Ankit Anand.
What is the ground for filing this application belatedly? You have also not gone through it. You have also not gone through. Listen to me. Don't read now, Mr. Counsel. Don't read now. You have not gone through. You have not gone through. Mr. Counsel, at least before this court, you should be very cautious about your impression because everything is live streamed. Everyone is seeing how you are conducting yourself in court. So you should be very, at least, you should have some concern about your own image. Forget about image of others. You should have concern about your own image and how you carry yourself. You are a junior counsel. These applications for condemnation of delay, at least you should go through it. Your senior is there to argue, let him argue, but at least you should know some facts. If the proceedings were not live streamed, the matter would have been different. Only 20 people sitting in this room will know how you are. But now, world at large is looking at it. The social media, they are reproducing it and retweeting it also, which I am getting this information. So, think about your own impression, what you carry, act accordingly, henceforth.
True, my lord. Lawyer is being watched all round the clock. The lawyer.
They don't. Not only lawyer, the judges also now. Don't say the lawyers, everyone.
Milord.
Under a very, you see, a wide angle camera. It's not a telescopic camera also. It's a wide angle telescopic camera.
Very true, man. Very.
Technically, a wide angle camera cannot be telescopic. But so far as judges and lawyers are concerned, the camera is wide angle and telescopic.
True, man. It's true.
But one thing is there, one thing is there.
Please.
Voice is not clear. Audio.